All right, back. This will be the people news. Never look straight forward. Always look around you. Be able to protect yourself by any means necessary. All right, arm yourself with knowledge. Use that Second Amendment. Okay. Educational purposes only. I'm not an attorney. I'm not giving legal advice. Why? Because it's educational purposes only. That's why. And I did not sign a bar grievance. Or, okay, I have signed a bar grievance, but I have not become a bar member. All right. Um, this is going to be part two of the Constitution Challenge. Let's go. And this is live right now, and the reason why I'm showing is for my benefit and keep it for here and on record for me to do research. As well for y'all, there's the case number if you got the money and time and effort and energy to research the case.
Um, and we can go through something else too, but we'll start off with this at least. So this is a notice of constitutional challenge pursuant to your Rule 5.
Now notice how they said it is your rules, not mine, but your rules.
Comes now the demandants, providing notice to the bought and paid for clerks masquerading as judges in this inferior legislative court and their handlers in the District of Columbia that their 1871 corporation domiciled in the District of Columbia. Guess I better silence that.
That one wasn't me.
Just it's amazing how many people always call at the most inopportune times. Anyways, so their 1871 corporation domiciled in the District of Columbia and its minor estate scam, 31 CFR 363.6, are unconstitutional as follows. So, first of all, the District of Columbia 1871 Municipal Corporation is unconstitutional because it's bringing Roman law onto the land of America. And this is Black's Law Dictionary, 4th edition. Civil law, Roman civil law are convertible phrases and mean the same system of jurisprudence, that rule of action which every particular nation, commonwealth, or city has established peculiarly for itself, more properly called municipal law.
All right, I'm going to pause right there. Because people have a tendency to kind of think from a citizen thing. Okay? But the case. All right? And it's just to cover that. And I asked to ask Google on one of my videos for you guys to hear as well. And Google even says, yeah, well, we kind of adopted the crap. Okay? Good or bad, I don't know. We haven't lived in such time that we actually went by common law. It's always been civil. Everything's commercial and all that kind of stuff. You know, we just become a creature of habit of not knowing these things.
To distinguish it from the law of nature and from international law. That's Black's Law Dictionary, 4th edition, which superseded and replaced common laws found in the Causes and Necessities for Taking Up Arms, 1775. Statutes have been passed extending the courts of admiralty and vice admiralty far beyond their ancient limits for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law, and instead thereof to publish and order the use and exercise of the law martial. And that's Causes and Necessities for Taking Up Arms, passed by the Continental Congress in 1775. because common law is the law of the land. And this is Hale versus Henkel. The individual may stand upon his constitutional rights as a citizen. His rights are such as existed by the law of the land long antecedent to the organization of the state. Antecedent means before.
So if you don't go to his channel for clarification,
long before the organization of the state, and can only be taken from him by due process of law and in accordance with the Constitution. Among his rights are refusal to incriminate himself and the immunity of himself and his property from arrest or seizure except under a warrant of the law. He owes nothing to the public so long as he does not trespass upon their rights.
now let's go with property tax, okay? Because this really is his battle with property tax as well here in Texas. And I have other videos talking about property tax from various different people. Where's the warrant, people? Where is the warrant?
Which is the same reason why we took up arms against the tyrant, and for all the grievances listed in the Organic Law of the Declaration of Independence, 1776. So the Declaration of Independence is basically a list of grievances. And then the minor estate, 31 CFR 363.6, that the County of Montague and their bar member handlers and the bought and paid for clerks masquerading as judges have assaulted the demandant with, is unconstitutional under Article 1 an amendment, which requires Congress shall make no law respecting an establishment of religion. So Article 1 an amendment, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. The minor estate was created by the Vatican, which is the Roman cult. Yet still it was found difficult to set bounds to ecclesiastical ingenuity, for when they were driven out of all their former holes, they devised a new method of
Conveyance. All right. Now, there's been a couple of them. The last one was the 1666, I believe it was.
By which the lands were granted not to themselves directly, but to nominal fiefs to the use of the religious houses, thus distinguishing between the possession and the use, and receiving the actual profits, while the season of the land remained in the nominal fief, who was held by the courts of equity, then under the direction of the clergy. That's the Roman cult, folks. To be bound in conscience to account to assist use for the rents and emoluments of the estate. Well, that's taxes, folks. And it is to these inventions that our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing. And that's Tomlin's Law Dictionary, 1835 edition, under the volume 2, under the definition of mort main.
And a step further. So if you read the act, right, in there, they actually said earth is a vessel, which gives them alleged ownership of earth, okay? I'm just saying, this is the way they looked at it. And, well, earth, the people on it, tacitly agreed to their terms. They stayed in silence of acquiescence. You can't make this shit up, people.
By the Sesta KV Act of 1666.
Yeah, there we go. I was right on cue.
And the tyrant. And this is the actual act. I'm not going to go through it. By the Sesta KV Act of 1666. And the tyrant. And this is the actual act.
Sorry. I'm kind of pausing it for y'all so you can kind of go through it yourself.
I'm not going to go through it, and was for land titles, and was brought into America with the Code of Law for the District of Columbia, 31 Stat 1432. Whereas,
What is it? We have land titles now instead of uh, the original agreement here in the United States. What is it? Right on the tip of my tongue. Starts with an A.
as the legal estate to be in necessity use, which is talking about land titles, and a use is short for usufruct under Roman law, which is a type of a trust, and a U.S. citizen minor estate entity is a taxpayer. Every taxpayer is assessed to a trust having sufficient interest in preventing the abuse of the trust to be recognized in the field of this court's prerogative jurisdiction. Citizen of the United States is a civilly dead entity operating as a co-trustee and co-beneficiary of the Public Charitable Trust, the Constructive Cesticate Trust of U.S. Inc. under the 14th Amendment, which upholds the debt of the USA and U.S. Inc. Congressional Record, June 13, 1967, pages 641 through 646.
As well as Title 28 USC 3002. What is it? B15. United States is a corporation.
So that's 5 pages. That's a summary of what 5 pages of congressional records say. And if anybody's ever seen the congressional record, it's extremely small print. It's 3 columns. So that's a summary of what those 5 pages say. It's also
it's on a scroll too, correct?